Good morning, y'all. Here we are, Gloves Off Podcast. Ven Johnson, Paul Doherty, Chris Desmond, Chief Appellate Lawyer, and our special guest today, Judge Amy Ronayne Krause. Judge, welcome.
Thank you.
We said before, once a judge, always a judge, but you just retired from the bench.
Yes, I did just retire just recently. So.
Congratulations, you're back in private practice.
I am. I'm with Chartier and Neem Fakutza, an amazing law firm in Okemos, Michigan.
Awesome. So what kind of stuff are you doing now?
Well, I have a criminal defense practice. We specialize in criminal defense. It's a boutique firm. That is their specialty. Trials, appellate work, federal, state cases, any kind of criminal defense work. That's our specialty. I'm also going to branch out into mediation, all civil cases and family law as well. So we're going to branch out a little bit now that I'm there. I would not be a judge. I would actually be there to mediate. And I want to say that for the lawyers, too, so that they know that I understand the difference between being a judge and being a mediator.
Right.
I get that difference, and I would be the mediator.
Well, best of luck to you on that.
Thank you.
So we're talking again today, folks, about governmental immunity. And for those that that either are living under a rock or not paying attention, in the last week, we have had more discussions publicly about governmental immunity. We've had actual printed articles with the phrase governmental immunity for one of the first times since I've been a lawyer. This is my 37th year. And folks are now starting to think about it and hear about it and discussing openly the inherent, what I'm going to call unfairness from my view. But we're going to talk with Judge Ronayne Krause and get her picture on that as well, her opinion. But Judge, real quick, you were on the Michigan Court of Appeals. Yes. Chris explained last time about trial courts, circuit courts, district first, then circuit, but we do circuit primarily. And then the next level, of course, is the Michigan Court of Appeals, and that's one level below the Michigan Supreme Court. How long were you a judge in the Michigan Court of Appeals?
12 years.
All right. And before that, you were a prosecutor, were you not?
Well, I was a district court judge for 8 years before.
Forgot.
That's okay.
Where?
So, in Lansing. So I was a judge for almost 20 years.
Okay. And so you were on the Michigan Court of Appeals, and so we've talked about in this podcast about governmental immunity, and obviously that issue came before you in the Michigan Court of Appeals.
Many times.
All right. I personally think it is inherently unfair to elevate the rights of one person against another, but especially when the government makes this rule, the legislature, and said, hey, you can't civilly sue my co-employees or my fellow government employees. Personally, I think that's wrong. So what is your overall global opinion on civil governmental immunity, knowing full well that we've carved out special rules if it involves someone who happens to work for the government? And where I always go with this is, just like in my Oxford school case, if that happened at a private school, we wouldn't be having this discussion at all. So it's special rules simply because you work for the government.
I think, to me, Ven, the issue is it depends on the case.
Right.
It really does.
It does.
Because there are certain cases where there should be some governmental immunity. But I have to tell you, overall, I agree with what you're saying, that governmental immunity has gotten out of hand.
Right.
Because let me say one case that I can remember, and I'm not going to remember the name, but I can remember it happened in Sault Ste. Marie. Okay. So there's a trip and fall in Sault Ste. Marie, and this poor person was injured, and the hoops that person had to jump through to be able to sue Sault Ste. Marie for the sidewalk issue. Right. They send everything. Sault Ste. Marie sends everything to the plaintiff, and the plaintiff was required under the statute to give all that information to Sault Ste. Marie. Well, Sault Ste. Marie gave them all the information, the plaintiff, and the plaintiff was required to send it back. And they didn't send it back. They said, you already sent me all the information in a letter. So I said, in my opinion, well, you have all the information because you sent it to them. That was basically my ruling. Right. And the Supreme Court overturned me. Now, this was back in 2012, maybe, so it was a different Supreme Court.
Yeah, it was the Angler Gang of Four, as I call it. But
well,
whatever.
You can call them that. That's absolutely what it was.
You're talking about the notice provision,
yes,
Judge.
Exactly.
Chris, and we all last time talked a little bit about that, but real quick, Chris, notice provision means what?
Well, so in certain types of cases under the Governmental Tort Liability Act, you've got the highway exception, the sidewalk exception, the public building exception, and then any cases in the Court of Claims. You have different notice requirements where you have to send a letter to the government and that letter has to tell them certain things. So in a highway or in a sidewalk case, you said it was. So in a sidewalk case, for example, you'd have to tell them, every witness to this accident, what my injuries were and the precise location of the defect at issue, which is where a lot of plaintiffs get, sort of tripped up, right? Sorry for a bad pun there. But so what happens, I mean, we're in the habit at our law firm, when we know that there's a defect, what we've been doing lately, we'll go to Google Maps and we'll pull up the actual longitude and latitude, the coordinates, and we'll throw that right into the notice so that there's no question that we were as specific as we could be.
Right.
But sometimes people don't know exactly where it was.
Right. And so to kind of focus on, Amy, on the issue that was before you in that Sault Ste. Marie case. So this is before there's been any adjudication on, did the person really fall? Didn't they fall? Did they get injured? We're not even talking trial.
No. And that's my point, is that to me, what was really frustrating about that case to me was, I mean, at least have a trial. I mean,
have facts.
There should be a trial about this. And they couldn't even get to a trial because of this, basically this loophole that I thought was ridiculous.
Form over substance.
Right. And the same thing with when you brought up the idea of road defects. That was another one where I had a case where it happened on Mount Hope Road in Lansing, so I happened to know it very well. Yeah. And the one location they had put was, they said westbound or they said eastbound, and then they put a picture of the other side. And I said, you know what? There's both of them.
Right.
They're both there. That's enough. And actually, that did get upheld.
Okay.
Because I said that was enough, and my other judges agreed, and so that was enough.
So in other words, it was the notice that the plaintiff attorney gave was good enough to satisfy the notice provisions
to go to trial. Right. And but, that one was upheld.
Right.
But again, that was one where it was quite a discussion to get it to go to trial. And I find it to be really disturbing.
Me too.
People have a right to a jury trial.
Right.
I mean, it's in the Constitution.
Right.
And going back to governmental immunity, we are talking about, particularly when we're talking about police officers, we get into a situation where we're talking about pretty dangerous situation.
Right. It comes up in every case. So in my Patrick Leoya police shooting case, a lot of folks know our firm's involved in that with Ben Crump. And we've alleged in the federal case, we put state claims, state law of Michigan claims, and federal claims. And we've alleged a violation of Michigan law as well. And guess what they're going to assert? Governmental immunity. So it comes up so often, Judge. And again, where I think what is so disturbing to me is if, for example, the poor person from Sault Ste. Marie, that trip and fall, let's put it in somebody's yard. So now instead of falling on the sidewalk, she unfortunately fell 3 feet over in the grass, and there was a 10-foot hole that wasn't marked and not guarded against or anything. She absolutely would have a right to sue that landowner. Doesn't mean she wins in trial, but she could sue, and she doesn't have to send a notice to that person at all. So why are we having to give notice to our government? I know what they're going to say. The naysayers out there go, hey, we want to make sure that it's a legitimate claim and that you're letting us know, because if there's a problem here, we want to fix it. But in your case, Amy, the government, Sault Ste. Marie, sent a letter to the plaintiff about where she fell. Right. So they knew where she fell and presumably, I hope, fixed it. So then when the plaintiff attorney didn't do enough or whatever they wanted to say in the notice, that's when you're talking about the two arms going like Scarecrow and Wizard of Oz, right?
Right.
It's like, what are we doing here?
Right. And, since this is the first time I've actually been able to talk about what I really think, which in 20 years, I want to talk about the notice in the Court of Claims, because that I thought was completely ridiculous. In the Court of Claims, it has to be the plaintiff that signs the notice. It can't be the lawyer. Mm-hmm. And I said, when I was on the Court of Claims, well, lawyers act on behalf of plaintiffs all the time.
Every day.
So I say, no. And I had the Assistant Attorney General say, well, nobody rules like that. And I said, well, okay, well, I just did.
Yeah, good
so,
for you.
And then I was overturned because they said, no, it has to be the complainant, the plaintiff has to sign the notice. And I thought, this is the only place I can think of where in the world where the lawyer can't act on behalf of the plaintiff. And then if it's not done right, who's to blame?
Right.
And
a non-legal person who would have no way of really understanding the requirements of the notice as specified in the law. We call it the statute.
Right.
All right. And then you're going to say that they have to sign it. It's complete bullshit. And this is why when I talk about governmental immunity, folks, what I say is it's the king says you can't sue me. Okay, but if I let you do it a little bit, they don't really mean it. And this is my point. At some point in time, maybe having a notice requirement to make sure that the government entity found out about the defect and could go fix it. Maybe that's a decent idea. But in the real life examples that we all now have lived and our clients sadly have lived for the last 25, 30 years, what we really know happens is that's all bullshit. And all it is an excuse for the government to try to come up with some technicality so they get thrown out of the case without ever going to trial. Fair statement or not, Judge?
That sounds like a fair statement to me.
So,
Ven, real quick, one of the last times that we were speaking about this, we were talking about the fact that there used to be a requirement that the government had to show prejudice, right?
Right.
There was a problem with the notice. That law changed. I'd be interested, Judge, to hear from someone who was making these decisions, how frustrating is it for you as a sitting judge to be bound by some of those prior decisions when you see the real world consequence of them? So in something like this Sault Ste. Marie case that you're describing, where you might disagree with the outcome, but you see the Court of Appeals has previously said in a published opinion, I have to do the following thing.
Well, in the Sault Ste. Marie case, I actually said that I thought that it didn't have to be that way, and I was overturned. But I thought that was an exception because I said that they did substantially comply because everything had come from the other side to the plaintiff.
First,
I thought it was that there was substantial compliance, and that's what I said. You know, I won't say which judge, but one of the judges with me said, well, I'll sign this, but it's going to get overturned. Right. And then it did. And that judge had more experience than I did. So he was right. And that's what happened. But I will say for me, the way you would know that I was feeling frustrated is if I would use the word constrained. I'm constrained to follow whatever case I said.
Stare decisis,
yes,
right? So we have to follow.
You have to follow it. And, you know, sometimes it was really frustrating. And I know this is going outside what we're really talking about today, but for example, in med mal cases, I mean, and I know that's a whole different area, not something that we were talking about today, but there's a place where I didn't understand that you could do something too soon in the law.
Oh God!
And
it throws your case out.
It throws your case out.
It's
and I went
complete bullshit.
And then you say, and my thought was, did it in fact
occur?
Did it in fact somehow prejudice your case because it was filed early?
Right.
And I'd like to send it back and find out if that happened. Well, you know, that was not allowed. You know,
still not allowed, by the way. Still not allowed to this day.
You file a complaint on day 182,
right, instead of 183.
Instead of 183, and you lose.
Yep.
Right. And that's the one place in the law where and again, this is the first time I've been able to speak what I really think. It's the one place in the law where if you do something too early, you're out.
Right.
And I mean,
so you're giving notice, you're filing the lawsuit, but it was too early. And this is where I go. Sorry, Chris, let me just finish. This is where I go. That shows you that although there may have been a good intent about having the law to begin with, we've absolutely allowed the pendulum to swing way too far the other way. All that law is, you're talking about the med mal law, but it's the same thing with governmental immunity. All that is an excuse to throw a fucking case up.
Well, and the thing is too, is I think people, for example, they talk about that McDonald's coffee case, like
all the time.
that was just a frivolous case. What they don't understand is if you really went and looked at what happened in that case, which I have done.
So have I.
Because I was tired of hearing people make fun of lawyers because of it.
Agreed.
And the coffee was scalding. It wasn't just like a little warm. I mean, it was scalding and caused serious injuries to that person.
Labial, it was an elderly lady, labial third-degree burns that required multiple surgeries to an elderly woman because she had the coffee between her legs and didn't know that the top wasn't on. And did you know that they had been cited 4 times for the coffee being too hot and it was burning people, and the health department actually cited them. So it was multiple previous issues.
And she only asked for her medical bills to be covered initially.
Right.
They just wanted them to take care of her so she wasn't out of pocket all of these expenses, and McDonald's couldn't afford to do that.
And by the way, remittitor was granted, which is a motion, folks, after the jury verdict, where they ask that the trial judge or the Court of Appeals reduce the size of the verdict, and it was granted. So it's like, what the fuck are we talking about? But yeah, no one knows that, Judge, and I agree with you.
And I only say that because when we're talking about governmental immunity, people think that we're actually trying to say things that are, that we don't think that the law should be followed, and that's not it. Or that we think that, silly cases should go to trial. That's not it. These aren't silly cases. They are important cases, and horrible things have happened to people, just like in the McDonald's case. And people don't understand that those horrible things that have happened sometimes aren't able to go to a trial because there's this immunity, and it's tragic.
It's a great point, Amy. Is that folks, when we're talking about governmental immunity, what we're really talking about is the overwhelming majority of cases that legitimately exist get thrown out of court and never go to a jury trial. That's just wrong. And Judge, we're here among the elite of the elite.
I know.
Because these two gentlemen, Chris Desmond and Paul Doherty, have the champagne victory in the Michigan Supreme Court on the notice issue. So, guys, Paul, tell us real quick. We mentioned a little bit about it. But
yes, this is a crazy example. Okay, so our client is on 696 in Macomb County. Sunday afternoon, going with a friend to watch the Super Bowl at his house. He's driving. A 25-pound chunk of concrete comes through the windshield, hits him directly in the face. He is blasted. Somehow he drives a certain distance. He doesn't know how far, pulls off the freeway into the gas station. Police come. They see the chunk of concrete in his lap. They take the chunk of concrete. They call MDOT. Said, by the way, you got a problem out here, guys. You've had a problem out here for years of this freeway crumbling. MDOT comes out the next morning. The police close the freeway that afternoon. They take the chunk. They walk 150 feet, and they say, look, there are thousands of potholes. We're never going to figure out where this came from. But it's from the road surface because of the markings. They give the chunk to MDOT. MDOT guy, supervisor, goes out there the next day. I can't figure out where it came from.
MDOT is Michigan Department of Transportation.
He orders a repatching of 5 miles.
5 miles.
So fast forward to our getting involved.
So in other words, they had notice. They knew it was their own co-employer, government employee said it was their junk, right?
Yeah. Right. 6 months before, the same thing happened to another woman. Hit in the face, comes right through the windshield. She spins out almost immediately, so they kind of know better.
So it's not coming off something else. It's
coming off the road surface.
The roadway.
It's probably a semi running over it, kicking it up in the air.
Got it.
You're going 70, so it's like it's coming at you 70 miles an hour.
Of course.
So fast forward, we do before the 120 days runs, which is the notice period. We have to give notice within 120 days.
Real quick, that's the notice. 120 days of what?
Of where the defect is, the specific location.
Of the incident, or when they go to a lawyer?
120 days from the incident.
From the incident.
But this is my point, y'all. So, you didn't know this. So if you under Michigan law have a notice requirement, if you don't go to a lawyer, and I love it when defense lawyers or folks, they went to a lawyer right away. You're fucking right. You should. Because in a situation like this, if you don't go to a lawyer or just happen to read this law that says you have 120 days from your incident, if you don't file that notice that we're talking about, which you won't know, you have no claim. They throw that out too. Go. I'm sorry,
we
Paul.
sent notice to MDOT. Didn't send it to the Court of Claims. All right. But before the 120 days ran, we filed the lawsuit. So we filed it in triplicate. It was on a piece of paper. So we filed it with MDOT, or with the Court of Claims. MDOT comes in and says, no, you didn't give us notice through the Court of Claims. Court of Appeals agrees.
Yeah.
Secondly,
throws the case out of court.
Throw the case out. Secondly, you didn't identify the specific location of the defect.
Even though the Michigan State Police officer, co-employee, if you will, another government employee, says, oh, yeah, it's from here.
Yeah. So Court of Appeals agrees. Court of Claims dismisses. Court of Appeals agrees. It goes to the Michigan Supreme Court. Michigan Supreme Court reverses on the notice issue, saying you filed the complaint within 120 days. That served as the notice. They remanded on the exact location issue. And fortunately, we were able to resolve the case before then.
And it's public, so we can talk about it.
Right.
It's $1.5 million settlement. Our client's face, and it's to this day, still doesn't have teeth.
No.
Because of how badly injured his jaw and his mouth was.
No.
So, and here's the point, folks. Paul, and that was also obviously Chris, because Chris works on every appeal in our office. Congratulations, guys. Great job again. But what's so important to me is, so after we won, the case wasn't over. We hadn't even gone to trial yet. And they came to us and paid a $1.5 million, which is a substantial award. And here's my point. They knew they were fucking wrong all along, but they play this game, right? And we all know the lawyer. It's the same lawyer. We had cases with Chris. You've known that. And that's his job. I get that. But this is my point. He works for us. And they're being paid to fuck us out of legitimate cases and claims. And then once they get caught and go, okay, now this is probably going to go to trial, then they finally step forward and pay. This is what I don't think people get is this is not like a potential, it might be, no, this is a slam dunk real case that they knew about. They were hiding behind this law. And then once they get caught and it comes out the right way, they step up, thankfully.
And this attorney doing his job, after a deposition, I talked to him, I said, look, you have two claims that arose out of this multi-million-dollar resurfacing project on 696. Don't you guys have any heart at all just to take care of these two people? There's just two. Their lives are destroyed by this. And he gave him a blank stare, and of course they weren't going to do it until after we'd done all the appeals. But that's just it. They don't have a heart. They don't say, look, these two people got mangled. The state police, before this happened, years before, issued flying debris notices for 696. So what are you supposed to do? Wear a helmet when you drive down in your car?
Right.
Well,
I mean, and most of it was property damage.
Perhaps we should.
People had
right. With a full face mask, apparently. And
I mean, people had chunks coming through their grills, destroying their cars. These two unfortunate people. I mean, literally, you look at the picture of the windshield, it's face level because the tire of the truck ahead of you is lined up basically with your face. So when that tire hits it, kicks it up, it's coming right through the windshield.
Thank goodness that you had a good Supreme Court to go to.
Well, let's talk about that because right now, people when they hear about the Supreme Court and they hear me talk and say, "Why do you always talk about number of Democrats and Republicans?" And the answer is, sorry, it's important because it matters. And I'm not saying that every Republican on the Michigan Street, and yes, folks, I know them all, and so I know who's who, and not just a Republican or Democrat, but who is fair and who's not. I know who's biased and who's not. Okay. And the fact of the matter is, without naming names, I'm not going to go there today, but it's absolutely important for us to know that it's 4-3 Democrat right now. And when it comes to the law, okay, so yes, I'm a Democrat. I admit it. But when it comes to the law, typically, Amy, is it fair to say, at least in the appellate level, that as a group, as a big, broad overview, Democrats believe more that the cases should be allowed to go to trial and have your day in court, and Republicans, at least the more extreme ones, don't, and they believe more in throwing the cases out of court?
Well, that is a tough question for me to answer with the court as it is right now, because I do think that there's at least, and again, we're not going to name names, but I think there's at least one Republican who is very open-minded.
Oh, I agree.
And very, very much a person who calls it as they see it.
I agree.
But I think that overall you are correct that there are that the Democrats are definitely, the Democrats are the ones that are supported by the plaintiffs' lawyers normally too.
True. Fair.
And I do think that even our Democrats, they'll call them as they see them too, and sometimes we don't agree with them. Let me just talk about one case also that dealt with an immunity issue that actually pretty much drove me crazy when I was on the court. I was, and I told you about this case. I was dealing with this case. It was a police chief, and it was out of the Thumb area. The police chief was at a concert. He actually ended up arresting somebody who was in a band or something like that. He got up on the stage and he was doing this arrest, and then he wanted the police chief immunity. but he was actually doing an arrest. So my point was, well, you don't get the police chief immunity. You were actually out there making arrests. The police chief immunity is for, you're sitting behind a desk and you're making decisions. That's not what this immunity is. And so Judge Fitzgerald and I actually he wrote the majority. We wrote it together, really. And then we had a dissenter, and the Supreme Court went with the dissent, except for the two people that went with the majority were Justice Markman and Justice Kavanaugh.
Wow.
Opposite ends of the
political continuum there.
So to explain to the audience what that means is that one of the rightist Republicans went with me and Fitz, and and another Democrat went with us as well. But it was just a very bizarre split. But ultimately, that immunity stuck with him. Right. So my response.
So the case was thrown out again.
Exactly, the case was thrown out. And I said to my colleague who was the dissenter, I said, well, you do know that that's the same immunity that we have and that the legislators
have. As a Court of Appeals judge.
As a Court of Appeals judge.
You should go arrest people then, Judge.
It's better.
What I said, it's actually funnier than that. I said, so next time we're on the bench, if I don't like what, the questions you're asking, I can just punch you.
Right in the face.
Because I have immunity.
Which is complete bullshit, of course. And that's not what it was governmental immunity is supposed to do.
And he said, well, I don't think that's right. I said, oh, look it up. I said, that is right. I actually have immunity under that statute the same way as the police chief.
Right.
And it was, of course I would never punch anybody, just for the record. While we're on camera here, just so you know, I'm not punching anybody. I wouldn't even know how to punch somebody. But at any rate, I just thought that issue, there was another time where I thought, how does this person get immunity when it was, what he did to that person was horrible.
Right.
Horrible. And the person was severely injured.
Right. Nope, that's what they do.
Well, and that's something we haven't really talked about is that idea of absolute immunity. We've talked about exceptions to governmental immunity, but there are certain officials that you cannot sue no matter what they do.
Like a prosecutor.
In
a malicious prosecution.
In the David Gavitt case.
Here's what I want to ask, Chris. Just on the Champagne case that Paul and you worked on and were successful, what do you think is the most important takeaway from that, in that the Supreme Court ruled? What was the count on Supreme Court, by the way?
We won 6-1.
6-1. So what does that tell you? Here's a notice provision. Amy talked about how bad it used to be. The fact that the Supreme Court kind of went the victim's way on a notice governmental immunity issue. What does that tell us?
Well, what I like about it, we've now had two decisions. So we had our Champagne decision, and the year before that, I believe there was a case called Wigfall versus City of Detroit, where the plaintiff won on a notice issue. City of Detroit said, you mailed your notice to the city attorney, and it was supposed to be addressed to the city law department.
Oh, no.
And Justice McCormick wrote a concurring opinion that was just fantastic, saying this is pure gamesmanship. This is outrageous that defense attorneys would try to do this.
Right.
So that case combined with our case seems to indicate that there's a little bit of a movement toward reason and fairness that's occurring.
Which is
great.
That
they're considering the fact, that they're taking a look. They haven't overturned this idea that the government has to be prejudiced, but they are looking with a little bit more scrutiny at what the government's arguments are and how they're using these notice provisions.
Amy, how do you see it? What's the takeaway?
No, to me that says a lot, because it changes everything, really. Those two decisions sound like, when you put those together, that they are moving towards giving, I guess, more leniency in terms of notice and so forth. That's a good thing, because that makes a difference.
So if they're...
And it was 6-1?
I think it was 6-1.
No, I think you're right.
Just
Zara was the only one, which is
interesting.
Not surprising.
Yeah. Well,
and you're welcome, Judge Zara, because whatever. But the fact of the matter is, if there's two notice opinions in a row, we'll call it that go toward more leniency and therefore allowing a plaintiff, an injured person, have their day in court, does that mean the Supreme Court may be open to looking at other governmental immunity issues right now?
Well, I certainly think so. My reading of the Supreme Court cases, in fact, the most recent Supreme Court case that I read was Janetsky versus the County of Saginaw. That was a Whistleblower Act case, and I'm not sure if either of you have read that one yet. No. It's a Whistleblower Act case. It was all about governmental immunity, because an assistant prosecutor reported on a chief assistant prosecutor who violated the Victims' Rights Act, so violated the Constitution and violated that victim's constitutional rights, didn't consult with the victim before a plea agreement. She reported on that because it was actually her case, and this chief assistant went outside of that boundary, is what I understand. And I'd have to go back to the case to read the specifics again. So if I misstate any specifics, don't anyone get mad at me. But the thing is that initially my old court, I have to start getting used to it. My former court said that she didn't have an action because of governmental immunity. And our Supreme Court has now said that she could go forward on a Whistleblowers Act against this chief assistant prosecutor. So she's able to move forward on the act because she was fired right after she reported that he had violated the Victims' Rights Act.
Well, ultimately, though, the ability of the Court of Appeals or the Supreme Court to sort of rein in the scope of governmental immunity is going to be based on their interpretation of the statutes.
Correct.
The problem, to have a complete overturning, we'd need the legislature to step in. So our courts have to
I disagree with that.
Take the language.
Sorry.
But we have statutes.
So what? Statutes get ruled unconstitutional when they are unconstitutional all the time, and it should. They usurp their power. The legislature told the judiciary, we're going to give special privileges to this group of people. That puts their rights above other people's rights. To me, that is absolute black letter law, equal protection violation. Sorry, but go ahead. Well, continue with your wrongness.
Thank you. But right now, the way they're getting reining it in is to take the language and either more broadly interpret it, i.e., exact location or notice. Do you have to file in triplicate? Do you have to give it to the Court of Claims before you file your complaint? Or is your complaint satisfy the notice? But as it exists, it's taking the letter of the law and relaxing its scope. Is that how you see it?
That's how I see it. That's what I think that they're doing. Particularly this Janetsky case, when I read it, I thought, wow, this is a real step forward to be able to say this assistant prosecutor actually was violated. And all it means is she gets a trial.
Right. It doesn't even mean she wins. No. And again, we're going to start there and end there, folks. None of this means simply because the case doesn't get thrown out before trial. It doesn't guarantee a win. All it does is guarantee that there's going to be a trial, and it gives the person the day in court. And that, I think, is a huge, huge difference. So we're going to wrap up episode 24, Governmental Immunity, Protecting the Guilty. Judge Amy Ronayne Krause, congratulations on your trial. Thank you for being here today.
Thank you for having me. I really appreciate it.
And stay tuned, y'all, because we're not done with governmental immunity. We're going to go even more into some of the cases that Johnson Law has had. We're going to talk more about the inherent unfairness and give you real live examples. So stay tuned. Look for episode 25 because it's coming soon. See you.